Hi, hello. This is rather a long talk, I'm afraid, but stick with it. I think you'll find it's worth it. I've just finished reading Bleak House. My favourite author is Jane Austen, and my favourite book is Emma, not Pride and Prejudice, but I'm afraid I do not enjoy reading Dickens very much. I know his plots are wonderful, his characterisation's incredible, and I appreciate the sections when the story moves forward, but there are just too many unnecessary words. I know the reason for the dense, impenetrable and opaque verbiage. You can tell reading Dickens is having an effect on my own style, but why did he not have the common sense to edit the novels after their publication in the weekly magazines and before they were published as books? I mean, who has ever actually read the opening chapter of A Tale of Two Cities? It is a mountain of language, piled up into an impassable wall of words, which quickly becomes not just futile, but meaningless and empty. On the other hand, properly and sensitively edited, his work can be fantastic, as can be appreciated in the current radio version of A Christmas Carol being read by David Jason on Radio 4. However, to return to Bleak House, Angela has always said that I should not comment on things, Angela's my wife, about which I know nothing. I've usually replied that there's no point at my age in changing the habits of a lifetime, but I did agree that I would stop criticising Charles Dickens until I had actually read a complete book. I have now done so, and I'm pleased to have done it, although I find much of it very heavy-going. It was particularly interesting because it is his book that focuses most sharply on the workings of the legal system. It seems to me that there is a great deal in the truism that the more things change, the more they stay the same. Both Dickens in Little Dorrit and Trollope in The Way We Live Now write in considerable detail about the irresponsible activities of banks and bankers, and it seems to me that great chunks of their plots and characters are still relevant today, as evidenced by the current hedge fund scandal in the United States. The law is no exception to these observations, and these thoughts passed through my mind as I sat in a Crown Court earlier this week, the activities of which, other than their length, would have done credit to Jarndyce versus Jarndyce, which is the core of the plot of Bleak House, in which a case in Chancery goes on for so long that every last penny of a valuable estate being challenged by competing claimants is absorbed by the lawyers, so that when it is finally resolved there is nothing left. The case being heard is one in which I've been involved as an expert witness, and was an appeal against a very questionable judgment by a magistrates' court earlier this year in a case brought by the RSPCA. I should explain at this point that the RSPCA is not one charity but many, and while the small locally based organisations do excellent work in caring for and rescuing animals in their region, everyone should be aware that although they have the name, they are independent, separate organisations who have to fund themselves and receive nothing, yeah, that's right, nothing from head office. If you leave money in your will to the RSPCA, and most of its income comes from legacies, it automatically goes to headquarters at Horsham when you pop your clogs. Your local charity, other than the very few shelters which are directly controlled by headquarters, do not receive a penny. So when I talk about the RSPCA, I'm referring to headquarters and their income of around £1 million per year. Its main preoccupation, it seems to me, is to generate publicity which will keep the charity in the forefront of the minds of people who love animals, so that when their solicitor suggests bequests, they are the organisation which comes to mind. In the case I'm talking about, a man had collected his two 10-year-old bitches from a kennel, which I have visited and can personally confirm is one of the best in the UK. One of the dogs, it is suggested, may have been lethargic and off its food for a day or two. Having actually managed a kennel, I know that most dogs are healthy and behave normally, and consequently you remember very little about them and their comings and goings. If a dog is not behaving normally or shows signs of sickness, you spot them very quickly. That's your job, and you do something about it. The kennel's veterinary surgeon gave clear evidence that the kennel tended, if anything, to be overcautious, and if there was ever a problem, dogs were taken in straight away. The kennel's been established for 20 years. It's got an unblemished record. The bitches were brought out of the kennel when the owner came to collect them, and one was quieter than usual, but not showing any symptoms of illness. Its hindquarters were wet, but it was explained that she had apparently, and probably inadvertently, fouled herself and been bathed. It's entirely reasonable. It is what you expect a good kennel to do. On his way home, the owner became concerned and told the court that he had smelled urine. He said the dog had not urinated in the car, and I personally wonder whether he smelled the remains of disinfectant, which is sometimes very pungent, and did not urinate at the veterinary surgeon either when he took the dog to his own vet 2 hours later. The young veterinary surgeon examined the bitch and diagnosed a likely pyometra. By the time it arrived on its table, there was some pus seeping from the vulva, so the diagnosis became easier. The bitch was put on a drip, and I'm delighted to say was successfully operated on the following day. You may not know, but a closed pyometra is extremely difficult to diagnose. It develops very slowly, usually a few weeks after a season, but shows no symptoms until the final few hours, when it advances rapidly and can lead to sudden death. Owners have put their pet to bed last thing at night, come down in the morning to find the dog dead or dying, having had no indication that anything was wrong, other than perhaps she was a bit below par the preceding day. Given the quality of care at this establishment, I am certain that had the bitch remained in the kennels for a few more hours, the discharge would have been noticed and she would have been taken to their vet. But the owner reported the matter to the RSPCA, saying the kennels had not properly cared for his dog. An inspector interviewed the owner, then turned up at the kennels unannounced and took witness statements from the owners and the manager. The kennel owners wanted to cooperate. They're nice people. They want to care for their dogs. They did not realise that the RSPCA inspector had no rights to take statements, and in fact the procedure was so poorly prepared that they were not finally acceptable to the court in any case. However, despite the facts, an unfortunate coincidence in effect, the RSPCA decided to prosecute. They got their headlines: ex-kennels to be prosecuted by RSPCA. On both occasions, had the whole process not been so distressing for those involved in the farce, I could almost feel sorry for the barrister acting for the society. He had no evidence of any substance, and spent hours, I mean hours, repeating questions over and over again, trying to get some sort of admission on which he could hang a case. In my evidence, I was asked a number of questions about the 1963 Boarding of Animals Act, about the model licence conditions, which I helped to write in the 1990s, and the Animal Welfare Act. His point was that kennels had a responsibility to take a dog to a vet if it was ill. I agreed. Of course they do. Unfortunately, there was no evidence that the dog showed any symptoms of illness when it was returned to the owner. At the magistrates' court hearing, the kennel owners were exonerated, but the kennel manager was found guilty by a magistrate sitting alone, who during the 2-day hearing complained of a headache and insisted that she go home early. Even in my layman's view, there was no case to answer, and the evidence presented was both insubstantial and unsatisfactory. How she came to her conclusions is a mystery. Fortunately, at the appeal, there was a proper judge who was patient and fair, had a grasp of the necessary evidence, of which there was none, was understanding and sympathetic to the distress of the kennel manager, was unbelievably reasonable in allowing what arguments there were to be put across, sensible in his assessment, although I felt was clearly frustrated by the determination of the RSPCA's barrister to drag inconsequential arguments out until they were stretched beyond reason, and came to the conclusion that was blindingly obvious from the start, that there was in effect no evidence of any value. He and his colleagues brought in a verdict of not guilty and awarded costs against the society. In my view, the RSPCA should be ashamed of themselves, not just because of the misery caused by this action and many others against vulnerable people all around the country who do their best to look after their pets, against hard-working and innocent people, but for the inevitable damage the media inflicted on the business by responding to the society's publicity machine, as well as the waste of the enormous sums of money which had been collected from ordinary people who believed they were contributing to an organisation which would use it to help animals in real distress. Happy Christmas!